Well, Roe versus Wade is most famous for singling out viability as the key moral consideration when thinking about abortion. It also uh, refers to personhood. It uses the moral consideration of personhood in its arguments, in its thinking, and what it's advancing. And so it appeals not only to viability, but also to personhood. And we considered viability and what it has to say about viability and how that works in a previous video. What I want to do now is examine what Roe versus Wade says about the person or personhood and how personhood features in the argument of Roe versus Wade. And this might seem actually in certain ways a little bit more familiar when we think about the ethics of abortion, even from a kind of, I'm not assuming that you've read philosophy articles on it before, but the popular arguments concerned with abortion, you may have heard people talk about personhood and when personhood begins and whether or not the fetus is a person. Roe versus Wade deals with those considerations, deals with those questions. And so let's examine what exactly it has to say about that. Now, and you can find this in section 9, page 16. Now, Justice Blackmun brings up the notion of personhood in response to the arguments that the state of Texas had made to defend their law, which had more or less completely prohibited abortion. And Justice Blackmun kind of lays out something like Texas's argument. And it's because of this argument from the state of Texas that Blackmun then has to go on and say something more about personhood. So let's look at the argument that Texas had given, or at least Justice Blackmun's construal of the argument, and then we'll look at what Justice Blackmun himself wants to say about personhood. So what Justice Blackmun is going to do is he's going to have to show that the fetus is not a person. And the reason he's going to have to show this is precisely because of Texas's argument. So here's apparently how Texas had argued. This is Blackmun's reconstrual of it. Texas had claimed that if the fetus, Texas had claimed that the fetus was a person and so had a right to life and so was protected by the Constitution and prohibitions on abortion were constitutional. What Blackmun himself considers is the following, based on that argument. Well, if the fetus is a person, if it's a person, well, then Texas seems to be right. Then it would have a right to life. And if the fetus has a right to life, well, Blackmun continues, the appellant's case, of course, collapses. That's the way Blackmun puts the point. The appellant would be Norma McCorvey, would be Roe, would be the person challenging the Texas prohibition on abortion. And so what he says there is if the fetus has a right to life, well, then of course Texas could have a law outlawing abortion. If the fetus has a right to life, well, then Norma McCorvey loses. The Texas law can stand if the fetus has a right to life. And so if the fetus is a person, well, then abortion can be outlawed. Texas can pass a law completely, more or less, prohibiting abortion if it so chooses. That is constitutional if the fetus is a person. It's because of this that Blackmun then takes it upon himself to argue that the fetus is not a person. Texas had rested a substantial part of their case on the fact that on the claim that the fetus is a person. Blackmun's going to try to, and if that works, if that's true, well then Texas's law seems constitutional, permissible, and so Blackmun is going to argue that the fetus is not a person. And he's going to give an argument for this. He does this in section 9. So the first thing Blackman notes is that in nearly all instances of the word person, right? So that word person is found in the Constitution. You can find it in various places. In nearly all instances, the word is such that it has application only postnatally. That is, that's the way Blackman puts the point. Postnatally, after birth. The word person in nearly all of its instances is such that it only applies to human beings that have been born already. And in the paragraph in which he puts this idea forward, he then cites a bunch of the uses of the word person in the Constitution. I'll give you one just to give you a little flavor of what he's talking about here, what he's talking about. So I believe it's I can't remember how it works. Sections or articles, which comes first? Article 1, Section 2, something like that, of the Constitution. Near the beginning. I think it's Article 1, Section 2. The Constitution lays out a bunch of kind of guidelines and rules for representatives, and lays out certain qualifications. There's an age qualification. No person, there's your word, shall be a representative who shall not have attained to the age of 25 years and been 7 years a citizen of the United States, and so on, right? So basically what it's saying, if a person wants to be a representative, they've got to be 25 years old and been a citizen for 7 years, right? Blackman is saying, look, this instance of the word person is such that it has application only postnatally, arguably, right? Maybe it only applies to 25-year-olds or whatever, something like that, right? It's only somebody who's going to maybe run for office. That doesn't have any obvious prenatal application, right? That's what Justice Blackman is getting at here, right? And we could go through the rest of the Constitution, right? There's all kinds of stuff going on in the Constitution. They're laying out all kinds of things, and Blackman gives us the citations. They're all going to be like that, is what he's claiming. Okay. Second thing he brings to bear, second piece of evidence he cites in favor of his position that the fetus is not a person. He says that abortion practices were far freer during the 19th century than they are today. And you might wonder at first glance, at least, well, why does that even matter? Who cares what they were doing there in the 19th century? Well, I think the reason that this is relevant, and Blackman doesn't state this explicitly, but I think the reason why he cites this as evidence is because the 19th century is when the 14th Amendment was passed. And what we're concerned with here is the 14th Amendment. Does the 14th Amendment apply or protect, put it this way, does the 14th Amendment protect fetuses, right? The 14th Amendment says something like, you can't be deprived, no state shall deprive any person of life, liberty, or property without due process of law. Well, does that apply to the fetus? Is the fetus protected, a fetus protected by the 14th Amendment? Blackman, the bit of evidence he's citing here, what he seems to be pointing towards is something like, when the 14th Amendment was written, drawn up, and ratified, the people who were writing it up and who were passing it would not, in all likelihood, have thought of the fetus as being protected by the 14th Amendment. Why? Because their abortion practices were far freer. Right? Those people in the 19th century who wrote up and ratified the 14th Amendment, they had far freer abortion practices. And so when they wrote the 14th Amendment, they likely did not have fetuses in mind as being protected by the 14th Amendment. Something like that seems to be the idea that Justice Blackman is getting at. And on the basis of these two pieces of information, or these two pieces of evidence, if you will, Blackman concludes that the fetus is not a person. So in philosophy, when we're analyzing arguments, something that I will commonly do, that you'll commonly see, that philosophers commonly do, is they arrange arguments in premise and conclusion form. And what that means is, you, so an argument consists of a conclusion. It consists of the thing being argued for, right? So Blackman in this case is trying to argue that the fetus is not a person. And then he brings certain reasons or evidence to support that. Here's why we should think that. Whatever is cited in the here's why we should think that, those are the premises of the argument. And in philosophy, we'll typically number the premises and we'll number the conclusion, and we'll draw a line between the premises and the conclusion. The line means therefore. So in nearly all instances of the word person, blah, 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 and 2, abortion practices were far freer, blah, blah, blah. Therefore, the fetus is not a person. Now, one thing you also notice, I didn't just, that's not just a typo there. It goes 1, 2, 4. That's all just Justice Blackmun, strictly speaking, says, but there seems to be an unstated but assumed premise to the argument. And many arguments are like this. There will be unstated but assumed premises. That's not in itself a problem. That's just how human beings talk and write, and that's fine. But for the sake of kind of being thorough and understanding how the argument works entirely, let's put the unstated and assumed premise in there. It would be something like, if in nearly all instances in the word person, blah, 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 and if abortion practices were far freer during the 19th century, well, then the fetus is not a person. That seems to be an unstated but assumed premise, because otherwise there's no real clear link between 1 and 2, and then the conclusion, 4. 3 provides that link, right? If those first 2 things are true, if in nearly all instances, and if abortion practices were far freer, well, then it seems that the fetus is not a person, or at least not a 14th Amendment person, at least not a person for the purposes of the 14th Amendment. Okay, so there's Justice Blackmun's argument. Now the question is it any good? We have it out there on the board. Is it a good argument? It's a logically valid argument. The logic works, right? There isn't an error in logic. Whereas if you didn't have that third premise and that was supposed to be it, there would, strictly speaking, there would be a problem there. The conclusion wouldn't follow from the premises. There's no link between the premises and the conclusion, but we'll put that third premise in there, right? Okay, so fine, the logic works. Logic is fine. But are those premises true? One seems true. No, whatever. Be fully honest, I've not looked at every instance of the word person in the Constitution. That would take a while, I think. There are a lot of them, but I'm willing to take Blackmun's word on it. And anyway, I've looked at a couple of them, and yeah, it seems true. All right, so 1 is true. Okay, fine, no problem there. 2, abortion practices were far freer during the 19th century than they are today. I don't know. I'm not a historian of 19th century legal history, and so I'm not entirely sure. I'm willing to say Blackmun is probably right about that too. Although, to be fair to Texas, at least, their law restricting on the abortion was on the books in the 19th century prior to the passage of the 14th Amendment. I don't know. He's not claiming all states had far freer abortion practices. He's just saying, in general, there weren't nearly as many restrictions. Sure, fine. Seems true. Or at the very least, willing to grant it to him. I'm not going to. And so then the question becomes, well, what about the link between those premises and that conclusion? Is that true? And I think that's, if there's a weak link to the argument, it's going to be that claim, this unstated but assumed claim, the connection, the presumed connection between the evidence, between 1 and 2, and then the conclusion, 4. That seems questionable. Well, why think that? One thing you might say, or you might argue, is that the way that the way that the word person is used in the Constitution is no sure guide to who or what a person is, or put another way, to who or what should be protected by the law. So, for instance, so just to say two things about that. First thing I'll say about that, somebody might just say, somebody who's trying to advance this objection to Blackman's argument, they might just say, look, the Constitution is not concerned with telling us about the nature of personhood and who qualifies and doesn't qualify as a person. It has much more practical concerns in mind. It's concerned with who can be a representative, who can be a president, who has the responsibility to do X, Y, and Z, and so on. It's not concerned with telling us who and who isn't a person. And so why think that the way that why think that the fact that nearly all instances of the word person in the Constitution, it only has application postnatally, why think that that gives any evidence for thinking that a fetus is not a person? It just seems irrelevant. The Constitution's not in the business of telling us who and who is not a person. That might be one way of starting to attack this third premise there, of criticizing this third premise. In a similar vein, somebody might point out the fact that, to kind of support further what I was just saying, the Constitution, here's a sign that the Constitution's no good guide to who or what is actually a person and deserving of protection. The bit that I have cited there from the Constitution under premise 1, no person shall be a representative who shall not have attained to the age, blah, 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 blah. If you keep reading that section of the Constitution goes on to talk about how many representatives each state will have. And representatives, the number of representatives that a House has in the federal Congress is determined by the population of the state. So California today, right now, has more representatives than Illinois has, and Illinois has more representatives than Wyoming has, because California has a higher population than Illinois, and Illinois has a higher population than Wyoming. There are more persons in California than there are in Illinois, and more persons in Illinois than in Wyoming. Well, one of the things that they then go on to talk about is, people who aren't free. So in particular, so at the time that the Constitution was ratified, this would have been slaves. They also talk about indentured servants, but slaves are going to be counted as 3/5 a person, is what the Constitution goes on to say. And you might think, well, and that was a compromise that they reached to whatever. We don't need to get into the details of that. But you might think that, well, look, slaves are clearly not 3/5 a person. They are a whole entire person. They are one person. They are persons. The Constitution counts them as 3/5 a person. That's a sign that the Constitution is not a very reliable, or it's not necessarily a reliable and good guide to who or what is a person, right? There's one clear instance where they kind of got things wrong. And if we were just looking at the Constitution, we'd be led to think kind of terrible things about some section of the population, yeah? And so just because the Constitution uses person in one way or another, that doesn't mean much, right? That would be a way of putting the point, another bit of evidence to bring in this regard, right? So that seems questionable. And you might raise similar concerns about the fact that abortion practices were far freer during the 19th century. So, well, okay, let's say that that's true. Why does that mean the fetus is not a person? Maybe they wouldn't have treated the fetus as a person, but maybe they were wrong. Maybe the fetus is actually a person and they were simply wrong not to treat the fetus as a person. And now we have the chance here in this court case to whatever, set the record straight or something like that. The mere fact that abortion practices were far freer back then doesn't seem to indicate with any assurance, at least, that the fetus is not a person. It seems kind of irrelevant. Another way of thinking about it, the law could be wrong. The practices could have been wrong, right? Go back to the 17th century and the earlier parts of the 19th century. And prior to the 17th century, go back 16th century, 17th century. Practice, so a similar point as I was talking about earlier, practices regarding slavery were far more allowed, if you will, right? Slavery wasn't outlawed until the middle of the 19th century with the 13th Amendment. So prior to then, slavery practices were far freer, say. Well, the mere fact that those practices were freer doesn't mean that they're legitimate or even that they should have been legal, arguably, right? And so somebody might raise a similar such objection here. The mere fact that abortion practices were one way or another back in the past is not any sure or necessary guide to how we today should think about these things. Maybe they were wrong back then. Maybe they were right. Maybe they were wrong. Who knows? The point being that an objector to Blackman's argument would be making is that the way people did things in the past is not of primary concern when we're figuring out whether or not the fetus is a person today. Okay. Now, I've been somewhat critical of Blackman. I'm going to pile one more criticism on and then wrap up with our discussion of Roe versus Wade. So Blackman thinks that he has shown with this argument that the fetus is not a person and so doesn't enjoy any 14th Amendment protections. Something easy to get confused about is that one way that you might think about Roe versus Wade is that it says, well, the fetus becomes a person at viability. That is not what Blackman thinks. The fetus is never a person. It only becomes a person when it's born. The fetus in the third trimester is not a person. It does not have 14th Amendment protections. All that happens in the third trimester is that the state may, if it chooses, pass laws to protect the life of the fetus. It's not a 14th Amendment person. It's not a person, according to Blackman, even in the third trimester. All right. One more problem, or, odd facet of his discussion here, of Blackman's discussion. Blackman thinks he's established the fetus is not a person with this argument. Okay, fine. But then he goes on to say something kind of curious in the very same section. He says the following: we need not resolve the difficult question of when life begins. When those trained in the respective disciplines of medicine, philosophy, and theology are unable to arrive at any consensus, the judiciary, so us, the Supreme Court, at this point in the development of man's knowledge, is not in a position to speculate as to the answer. And so Blackman, in this quotation, seems to be punting on the question of when life begins, right? I'm not going to touch that one. No thanks. That's hard. Nobody knows. It's or whatever. It's very controversial. People debate it. When life begins, I'm not going to say anything. But it seems like, well, okay, that might seem a little bit odd because he seems very confident about the fact that the fetus is not a person. He seems very confident about when personhood begins. And so he must be assuming that there's a distinction between life on the one hand and personhood on the other hand. Now, that is not in itself problematic. A lot of people do that. A lot of philosophers that we're going to read are going to do precisely that. And it's you know, it's a viable way of proceeding, of trying to think through these issues, or at least lots of people have done that. Okay, so that's not problematic. But what we're going to see going forward is that for virtually all philosophers, this is pro-choice, pro-life, whoever, Blackman gets things exactly backwards. Personhood is the hard one to determine. Life is the easy one. We're going to see Peter Singer make this point most forcefully, but he's a pro-choice philosopher. He thinks, no, it's really clear when life begins. That's not hard at all. Life begins at conception. The hard question is saying when personhood begins. And that's what Singer is going to devote a lot of attention to trying to settle. And the relevant question, Singer would argue, is when personhood begins. That's what's relevant to the abortion debate, not when life begins. And so this is a kind of, and so what does all this amount to? This amounts to maybe just pointing out that there's a kind of further confusion in Blackman's thinking, apparently. When life begins is not hard. And really, the disciplines of medicine, philosophy, and theology, when they're properly construed, are not arguing over that. They're arguing over when personhood begins. And that's precisely the question on which Blackman does not punt, right? And so if anything, he should have gone the other way, it seems. He could have very definitively said life begins at this, but personhood, who knows, or whatever. But that's not what he does. He claims that claims to have shown that personhood, that the fetus is not a person, and so that personhood begins at birth. But when life begins, he punts on. All right. Now, in this video, in the previous video, I've been very critical of Roe versus Wade. I've been showing problems that the arguments run into. I want to reiterate at this point, however, that just because, well, let me state two things. First, these criticisms are not original to me, at least not all of them. These criticisms, at least many of them, have been made by other thinkers, have been made by other pro-choice thinkers. Just because Blackman's arguments are not good, or at least that's kind of my opinion, they don't work, that doesn't mean that Blackman at the end of the day is wrong. That doesn't mean that we have to be that we have to agree with that we have to disagree with Blackman's conclusions. All it means when we criticize Blackman's arguments like this is that his arguments don't work. Maybe he's got the right conclusions, I don't know, but his arguments don't work. They don't get those conclusions. Because it's possible for someone to give bad arguments for true conclusions, and vice versa, right? It's possible for people to give kind of challenging good arguments for false conclusions. All right.